So our next speaker or panelist is Flavio Peter. Flavio is a counsel at Wenger Wely in Zurich, Switzerland. He represents clients in arbitration and annex proceedings. In addition, Flavio is a visiting scholar and lecturer at the University of Zurich since 2015 and author of several publications in his fields of experience. We also go back, Flavio. We've been together to Berkeley Law and sat in class and in Andrew Guzman's class of international arbitration.
Exactly.
So today you will speak about the Lex Arbitri, the changes to it in Switzerland, and I'll hand it over to you.
Thank you very much, Chris. Thank you very much, Berkeley Global Society and Osborne Clark for hosting this and for having me. It's my absolute pleasure to be here. Of course, also with you guys. I'm trying to set up the screen, so let me quickly see whether that works.
Yes, that looks good.
Okay. Well, today I was thinking about what sort of trends do we have, and gladly, just recently, the Swiss Parliament passed a revision of the so-called 12th chapter of the Swiss Private International Law Act. That was 3 weeks ago. It's been debated for like 2 years, 3 years. The 12th chapter of the SPILA, as we refer to it, is the Lex Arbitri governing international arbitration. Domestic arbitration in Switzerland is governed by certain provisions under the Swiss Code of Civil Procedure. International arbitration is governed by the 12th chapter. The SPILA was from the 80s, so it was like 30 years or well, soon to 40 years old. It was drafted in parallel to the model law, so it's not an uncitrul model law enactment or replication. It has its own sort of logic, but it's obviously content-wise quite similar. But since it was from the 80s, it was about time to modernize it. And so the aim of the revision was sort of to maintain and enhance the attractiveness of Switzerland as one of the preferred seats for arbitration internationally, but then also to align it with case law and practice in order also to actually increase the user friendliness. There was a lot of things going on that were not really written in the 12th chapter that needed to actually be put to paper, and obviously a couple of gaps that needed to be filled as well. For you, I thought to focus, obviously to give you an overview of certain of those changes, but then to focus on those that may be of international value also for your own practice. So let's see how this goes. So generally, as mentioned, the revision aimed at aligning the SPILA with the practice and case law, for example, that pertains to the remedies available in relation to an arbitral award. There was not only the challenge or the setting aside, as you may call it, of an award. Obviously, it is also possible to have the award revised. So if there's any facts that you become aware of only after the award has been rendered, but that fact or circumstance may have an effect on the judgment itself, you may apply to the Federal Supreme Court for a revision of the award, and you can do so within 90 days of becoming aware of such circumstance. And that was already possible, obviously, but it is now put to paper. Same goes with the correction of an award in case of clerical errors in the dispositive section, or the interpretation of an award if something in the operative part is unclear. Also, same applies to an additional award. So if the tribunal omitted to decide on certain issues that were pleaded by the parties, but it simply did not decide on. The party have a right to make an application to the tribunal to render an additional award. That was one of the things, as mentioned. I mean, that was already done in practice, but it was not reflected in the SPILA up to now. The same goes with a need to object in case there's a procedural violation. I guess we would all agree that we are familiar with that concept, as if you do not object to a procedural violation, such objection will be deemed to be waived. And another last aspect, a little bit more trivial, I would assume, is that local courts would give assistance to arbitral tribunals in summary proceedings and not with like full proceedings under the Swiss Code of Civil Procedure. So that is basically what alignment meant, a couple of those aspects. Now, if we stay with the assistance of local state courts, I think it might be interesting for you to know that what has been implemented newly is that local state courts in Switzerland may also give assistance to arbitral tribunals abroad. So this sort of concept you may recall from certain classes that you might have had in Berkeley or elsewhere, and you might have heard of the 28 US Code, section 1782, which would apply to courts in the US that could assist international tribunals abroad for the taking of evidence. It's about the same notion. However, now what has been implemented in Switzerland is a little bit broader in scope, meaning that local courts in Switzerland could also give assistance to interim measures, and in addition to the taking of evidence. What, of course, you need to be aware of that, for example, if you have an arbitration or whatever, an arbitration in the US that may follow some sort of US style techniques or US approaches to document production, like discovery, you're unlikely to get assistance by Swiss courts because they will apply the Lex Fori to see what they actually can assist with, and US discovery is certainly not something that Swiss courts are familiar with, and between brackets, much less something that Swiss courts would probably want to support because it's just different in nature. But just for you to know, like there's this possibility to actually then go around to circumvent the usual way until now of judicial assistance that we had under certain Hague conventions, etc. You can do that now directly, based on this provision in the SPILA, in the new provision. Another aspect of the revision of the 12th chapter was that we included specifically also the provision that, let's call them statutory arbitration clauses or one-sided arbitration clauses that are contained in testaments or in trusts or articles of association. They are also valid. I think the general discussion that followed that suggestion to actually make it part of the SPILA was really much about the question of consensus, whether there was a valid arbitration agreement if a person, for example, writing the last will, was just including an arbitration clause and the heirs basically had to accept the arbitration clause. Did they voluntarily consent to the arbitration or not? I think that sort of discussion has now become redundant because the parliament actually said, yes, that is sufficient for consent, that is an arbitration agreement. That's one of the things of the novelties. And what is also interesting is in case of pathological clauses, and that would be the second bullet point, if you have an arbitration clause that does not provide for any seat of arbitration at all, or if it provides for arbitration in Switzerland, that might have led to certain problems, particularly if the parties could not actually get their heads together to constitute a tribunal. The question was, where was the seat, which was the local court to actually make a motion to for the constitution of the tribunal. This has been solved in a way that claimant can choose whatever court it does want to go to in Switzerland. So theoretically, if you ever encounter an arbitration agreement saying the parties agreed to settle all the disputes in relation to this agreement by arbitration, full stop, not giving any seat of arbitration, you might want to think about to come to Switzerland. Go to any court in Switzerland, if you have problems with constituting the tribunal, you might go to Switzerland, seizing any court of your choice. And by that, you probably would also designate the lex fori, the lex arbitri to be applied, making it sort of connected to Switzerland. Now, the last feature, and again, something for our colleagues internationally, is that the Parliament has decided to allow the setting of side motions, so the challenges of arbitral awards in English language, to go to the Federal Supreme Court. To date, the Swiss Federal Supreme Court did already accept exhibits in English. So if you had an award and the entire arbitration was in English, if you had an award in English, you could obviously submit all relevant documents to the Federal Supreme Court in the original language, but the main submissions, the main challenge had to be in one of the official languages, being like German, French, or Italian. Now, this new provision will allow parties to actually also submit the challenge in English. That will reduce costs and efforts for translations of certain documents. That would also, and that is probably contra from a Swiss perspective, that would also eradicate the need of Swiss lawyers, because if you're admitted as a lawyer in the EU or in EFTA states, member states, you are also allowed to go in front of the Federal Supreme Court. And if you have an arbitration already in Switzerland, you might as well just go to the Federal Supreme Court. So Chris, Mr. Kirstein, if you want to in future go to the Federal Supreme Court, you can do it all by yourselves. No need for us. And all in English. Obviously, you probably want to recheck whether that is favorable to go in front of foreign courts, which may apply their own parochial understanding of certain rules, but I'll leave that up to you. So basically, key takeaways for you. If you need assistance of local courts for international arbitration abroad, come to Switzerland, no problem. We have no seats of arbitration, no problem, come to Switzerland. And if you want to challenge an arbitral award in English, of course, do it in Switzerland, no problem at all, do it yourselves.
That sounds promising.
Yeah.
Well, thank you, Flavio. That was really interesting.